There's Judge Eisnagel. Well, good morning and welcome to an oral argument session, remote oral argument session at the 5th District Court of Appeal. I'm Judge Orfinger, and I'm joined on the panel today by Judges Koell and Judge Eisnagel. And we have the case of Estate of Dandar Schultz versus Citrus Memorial Hospital. Both sides have 20 minutes. The appellant can reserve as much time as he chooses to. The clock has been preset to 5 minutes. If you want something other than that, let me know. And we'll be happy to alert you when you get into your rebuttal time. When the light flashes yellow, you're in your rebuttal time. Can both of you see the clock okay?
Yes.
Yes, Your Honor.
Yes, Your Honor.
All right, well, let's go ahead and get started. So appellant, you may proceed.
Yes, Your Honor. Attorney Timothy Dandar, and I would like to reserve 5 minutes for rebuttal.
All right.
And this matter surrounds the death of a Dandar Schultz on May 30th of 2016. And following that, we have counsel represents or was retained by the wife of Dandar Schultz.
Mr. Dandar, let's go ahead and just kind of get to the legal issues that are involved. Would you agree that the requests for discovery were not properly complied with?
Yes, during the pre-suit timeframe, the request for discovery, it is agreed that my partner, who was the primary attorney on that case, and as was mentioned within the reply brief, he did not comply with those. There were numerous issues going on within his life, as was mentioned, the situation dealing with his daughter's student
I
out of
understand.
Texas.
So that's not the issue. So the issue then is simply what for you? A matter of prejudice? Is that your argument?
Well, yes, the issue comes down to, as was discussed within the Florida Supreme Court case of Morris v. Muniz, which is the citation for that is 252 Southern 3rd 1143.
We're familiar with the Morris case, but the Morris case, under that circumstance, the doctors already had the information that they were seeking during the course of discovery. So I don't know that case is availing to you. So I'm still trying to really understand where you're coming from on the prejudice argument.
Well, when there is the alleged, as to the prejudice, and really it comes down to the failure, because as the Morris v. Muniz case states, because dismissal is the ultimate sanction in the adversarial system, particularly in medical malpractice realm, and as is the case here, the statute of limitations has already expired. It should be reserved for those aggravating circumstances in which a lesser sanction would fail to achieve the same result. And in those situations where, as is the case here, the attorney and not the client is responsible for their courts should consider the factors that are set forth in Kozel in determining whether dismissal is warranted. And
Kozel deals with discovery violations during litigation. Isn't the purpose of the pre-suit discovery somewhat different? And then, in other words, it's to both let the parties determine before a lawsuit is filed the relative merits of their claim or their defense. And if the claim is meritorious or the defense is meritorious, to allow the parties to try to resolve the case or perhaps go to arbitration. So it seems to me that while there are some similarities between a discovery sanction and a sanction for failing to make pre-suit investigation material available, they serve different purposes here, don't they? I just don't know. Have you seen any cases that have applied Kozel to the failure to adequately pre-suit a mid-mal case?
And that is the issue here, because it really comes down to, and I think it's very difficult time in that there is no preceding case law from, and it's a very difficult issue, is what rule is to be applied. And because as is stating, the failure to comply with it could result in dismissal of, and that is, it's the question becomes what threshold is to, and then also, and really what threshold to apply. And that's why in the reply brief, it was stated the threshold of, and the determining factors, since there is no case law as to the pre-suit discovery, well, it's depriving the access to the courts of these of the citizens. It's the threshold to be applied then is well established as to discovery, and once a lawsuit is actually filed.
Well, you've got the Wilson decision, you've got the Koell decision. It's not like there isn't any case law that addresses the issue of the failure to comply with discovery in this context.
Mm-hmm. But in this matter, it pertains to the fact that it was of no fault of the of the actual plaintiff, of the actual client, but rather due to the issues that were surrounding the counsel for the plaintiff. It was
but does the statute,
it was not lawful.
All right, does the statute make that distinction?
The statute does not, and that's where, for clarity as to that, since the statute does not, then we look at the most parallel case law that we have on that matter is when there is the case law pertaining to discovery during litigation. I mean, because it could be the case where there is zero, after you have the discovery request sent, the other side could just sit on their hands and just hope that the one side doesn't respond. I mean,
but your interpretation would effectively abrogate the requirements of the whole pre-suit process. All you have to do is not comply and then say, well, it wasn't the client's fault, it was the lawyer's fault, and so you'd have a meaningless pre-suit process.
Mm-hmm. And that's I think that's an excellent point, certainly, and that's why I would like to also primarily focus on the prejudice, since there does have to be the actual prejudice. And I believe, and so what we have is, as was mentioned by Judge Orfinger, as to liability, what are they unable to defend themselves as a liability? And it occurred within their hospital, so they do have all of the medical records there. We did provide the affidavit we did provide the affidavit of Dr. DeSteffens. So there was sufficient information available to the defense in order to, review and investigate as to liability. So the issue comes down to, as was the second point, estimating the amount. And I believe that that's where the primary focus of defense of the defendants is as to their prejudice, and that is saying that because there was no discovery responses by plaintiff, they were unable to really assess the viability of settling and for what amount. And as to that, and while it is a great point, there are other aspects, such as the fact that the deceased was an employee of defendant's hospital. So they are familiar with who the defendant is. And then also, they would also have within the records, I believe there's indication of occupation as well. So because so it really comes down to the prejudice, and I would argue that it was insufficient for them to actually show to establish that there was prejudice by the defendants because of the information that was available, and it's a unique set of facts that we're dealing with because of their personal relationship with the deceased.
Okay, anything further?
I'll yield the floor.
Okay.
May it please the court. Jason Azzarone on behalf of the hospital and Dr. Glenn. Your honors have essentially made my argument for me and hit the nail on the head. There are no cases that address the Kozel factors in this context with a plaintiff's complete failure to respond to pre-suit discovery. There are no cases that address this exact situation other than the cases that I've cited in my answer brief. I think what we're looking at is plaintiff's, the appellant's argument that prejudice needs to be shown, number one, is incorrect. I think the Koell case that was cited by Judge Koell and also the Dressler case both show that in the context of a complete failure to respond to pre-suit discovery, what needs to be shown is that there's a reasonable explanation for not responding. And in this case, that hasn't been shown.
Well, counsel, how about the reasonable explanation that you didn't comply with the statute?
I think the lower court found that we did actually comply with the statute.
Maybe I misread the record. Did you submit a notice demanding an unsworn statement? And did the notice give the time and place for taking the statement and the name and address of the party to be examined?
If you look, and I apologize for turning away from the camera, Your Honor. If you look at the court's order, and I'm pointing specifically to record page 426 and 427, the lower court actually found that, yes, we did request the unsworn statement. And that was also the email.
Counsel, I'm not really asking you what the trial court found. I'm asking you, does the record demonstrate that that's correct? Did you?
Yes, it does. It absolutely.
Where is your notice which states the time and place for taking the statement in the record?
The notice was in the original notice, the response, which was attached to the motion to dismiss at record 182 and 183 and 184. There was also an email that was sent and again attached to the motion to dismiss, and that was contained at record 190.
And both of those contained the time and place for taking the statement?
No, they did not. They actually requested that information from the plaintiff.
So we just went through that whole back and forth, but now you concede that you did not comply with the statute, correct?
Absolutely not, Your Honor.
Does the statute require you to state the time and place for taking the statement?
I do not believe so. I believe what it requests is that we have to actually ask for the time and place, and then we get that set up through.
Well, counsel, let me read it to you. It's under 6B1. The notice must state the time and place for taking the statement and the name and address of the party to be examined. Did you comply with that?
That would be when we're given the information by plaintiff's counsel so that the notice can be actually prepared.
The statute doesn't say that. Did you give the time and place in your notice?
No, Your Honor, it's not contained in the record.
Okay.
But there were requests made.
But your position is that sentence wouldn't apply until the other party gets back to you and essentially approves a time and place?
The same as any deposition that you would conduct. Yes. So if I want to take the deposition of someone after.
But you can see that's not in the statute anywhere.
I don't believe that's in the rules of civil procedures either. Counsel is supposed to confer with each other, talk to each other, and make sure that the days are together. As
a matter of professionalism, they absolutely should, right? But I'm asking you about the statute 766.106.
Was that actually done? No, the record doesn't reflect that there was an actual notice done, but there were requests for that.
Do you think that perhaps if the other side isn't getting back to you, instead of letting the clock run out, do you think you should go ahead and send a proper notice then, because they haven't gotten back to you to confirm a time?
I think the proper professional thing to do is to keep asking, and that's what was done in this case, and that's what the lower court found.
So counsel, you think the professional thing to do is to not comply with the statute?
Absolutely not. It's not what I'm saying, Your Honor. What the professional thing to do would be to continue to ask for dates, continue to ask for the responses, and the lower court found that we complied with that requirement.
But all I'm asking you is that once you realize the time is going to expire and that the other party has not gotten back to you, what I'm asking you is it the better practice to go ahead and comply with the statute as best you can, or to sit back and let the clock run?
I don't think either of those are the correct thing to do. I think what the professional thing to do would be to continue to ask, because if we just set the depo or the unsworn statement at a time when the other party is available, then we're met with an objection. That's what happens in practice.
Well, but at least at that point you've complied with the statute, counsel.
Well, again, I don't think that the focus should be on exactly what my clients did or did not do. The focus should be here on the failure of the appellant and the appellant's counsel to do what they were supposed to do.
But counsel, that begs the question. The question is, maybe it's a chicken and egg question, right? My question is, did you even make a request for an unsworn statement? That's
reflected in the record, and the lower court found that.
Yes, you did make a request, but you didn't make a request pursuant to the statute. Your request didn't comply with the statute.
Well, again, Your Honor, I will concede that there is no formal notice contained in the record on appeal. However, if I set a deposition and I do it unilaterally, I met with an objection. And that's basically what Your Honor is asking. Did we do that? Did we set something unilaterally? No, that didn't happen. The record doesn't reflect that. But again, Your Honor asks, did we sit on our hands? That absolutely didn't happen as well. We continually asked the plaintiff to provide us with the responses, to provide us with the information. And it also begs the question, Your Honor, how can we take an unsworn statement without having the information? That's all part of the process. We don't go through in civil court. The process isn't take the depo, then get the information via request for admissions, request for interrogatories, or request for production. We get the documents, we get the answers so that we can actually have a meaningful deposition. In this case, what we're looking at here is, and it kind of goes to the prejudice that Judge Koell and Judge Orfinger talked about. My client didn't have the information. We may have had some information, but the very important information that would have gone to the question of whether we would have sought arbitration had to do with damages, had to do with the number of survivors, had to do with the medical bills, the lost wages. In our office recently, we had a case very similar, under very similar circumstances, where, as we later learned, it was a case of pain and suffering damages. All of that goes into the decision as to whether to seek arbitration.
Counsel, tell me what information you could not have gotten from a properly noticed unsworn statement.
We couldn't have gotten the medical bills as admitted to in the briefs. We couldn't have gotten the lost wages as admitted in the briefs, because the briefs that were submitted by the appellant said the woman didn't know anything. That's actually argued in their brief. The wife of the decedent didn't know anything, so her deposition or her unsworn statement wouldn't have provided any information. Those aren't my words; those are the words contained in the briefs of the appellant. So again, where do we get this information from? We get it by following the channels, following the proper procedures of the Medical Malpractice Act, which requires this. It's also important to know that Plaintiff's Counsel's office isn't new to the medical malpractice world. They practice this a lot. My firm has many, many cases with Mr. Dandar and Mr. Dandar. And the requests for information that went were no different than are asked in every other case. It's not like these were a unique set of circumstances where the questions asked and the information requested was different than any other case. We asked very simply all of the things that are asked in general medical malpractice cases. The reason for this, again, is because by statute, we are limited in the amount of time that we have to either deny the claim, accept, or request arbitration. And that's where the lower court correctly found prejudice in this case. We weren't given that opportunity, Your Honor. We weren't given the opportunity to seek the protections of the Medical Malpractice Act to say we want to offer arbitration. And as Your Honors all know, if we offer arbitration and it's accepted, the very damages that the appellants said was the only damages at issue in this case are minimized. if the plaintiff says, we don't want to accept arbitration, again, pain and suffering damages are capped. This is very important, and this is the very prejudice that my client suffered in this case. The appellant argued that we shouldn't just dismiss a case where there's a lesser sanction. There is no lesser sanction in this case, unfortunately, because of the timing of the case. Plaintiff's counsel waited until the 11th hour to file the case, had to seek the 90-day extension of time to conduct pre-suit, submitted the affidavit. We advised multiple times that the documents weren't correct, that we needed responses, and there was simply no response. Again, the Judge Koell and Judge Orfinger brought this up. The cases that are cited by the appellant all talk about where there are minimal responses, or you don't think the responses are good enough, or there needs to be more information. That's not this case. The cases that I cited in my brief all speak to instances where there's absolutely no response. And because of that, the lower court did not abuse its discretion in ruling as it did. And I have not heard anything from either the appellant in this case in the appeal or from below that said there was an abuse of discretion. The lower court's order has findings of fact, establishing what was done, a timeline, how my client responded, the number of times we sought information. It goes into where prejudice was actually found, even though as I argue in my brief, it's not necessary. So what we're looking at here is a situation where the court was really left with no other option. We are looking at the statute, and the statute says if there is no compliance, the case gets dismissed. The case just gets dismissed. There's really nothing left. And counsel at the first argument on the motion to dismiss acknowledged that if it was dismissed, it would be essentially with prejudice because of the time frame. I believe that there's been absolutely no showing in this case that the lower court abused its discretion, and that is what is required for this court to reverse the decision. Given this, we respectfully request that this court affirm the decision of the lower court. Thank you very much.
Thank you, counsel. Mr. Dandar, you've got a little over 10 minutes left.
Okay, thank you, Judge. Just very briefly, as to, I believe, one of the final arguments as to the no showing of or no argument as to abuse of discretion, I do believe that that is exactly one of the arguments that is being raised by plaintiff here, was that there was an abuse of discretion because of the lack of a sufficient showing of prejudice.
Well, counsel, I mean, if you look at the statute under 7, I mean, it just says failure to cooperate by a party during pre-suit investigation may be grounds to strike the claim. Mm-hmm. I mean, it doesn't say that prejudice is required. There's a complete, do you agree there's a complete lack of cooperation in our record?
Well, while I would say that there does not seem to be, and that's what's interesting about that, that statute is it doesn't really provide any level. I mean, you could have it be where there's one question in all the discovery that's not answered, and then the other side can move to dismiss as to that. In the end,
counsel, that's not our case, right?
That is correct. But in the end, what we do have is that plaintiff did comply with the statute by providing the notice of intent timely, also with the corroborating affidavit timely. And then as to the documents that were the crux of the issue here, which pertain to lost income and loss of consortium for damages, those documents, I believe that counsel had mentioned that having it through a deposition of the person representative, the wife of Dan Ray Schultz, that having a deposition would not answer those questions, but she is the only individual that would be providing those documents of lost income. So, as was discussed regarding the 766 by Your Honor, 106B1, and in that stating, because while counsel is correct that we have had a number of cases in the past, if there is an issue with some sort of delay in providing dates and times and places for deposition, the customary practice is to say, if I don't have dates by such and such a time, then I will go ahead and provide tentative dates and times and places for those depositions if I do not hear back from you by, Friday on whichever date. And then the deposition could have been ducis tecum, wherein those same exact documents would have been provided. And it should be mentioned that counsel does normally comply with those requests during pre-suit for discovery. It's just because of these extenuating circumstances and unfortunate circumstances that counsel was enormously distracted, from this matter, due to the trying to save the life of the 8-year-old girl out of Texas. So it's a very rare occurrence, and so that should be taken into account as well. One moment. Okay, and so in the end, they also did not comply with our requests as well as was okay. Let's see if there's any other notes. My apologies. Okay. If there's no other questions, that'll be it for appellant.
Thank you.
Thank you.
Thank you, counsel. Thank you both. That'll conclude the argument on this case, and we'll see you next time. Thank you. Have a great day. Bye-bye.
Thank you, Your Honors.